Hello, everybody. Hello.
Good evening, sir.
Very good evening.
Good evening. Good evening. Shankar has already joined,
Uh-huh.
and right now we have around 12 members present over here, 12 participants.
Oh, only 12. Okay.
We have around 45 registrations, so we can start by 4 or 5.
Oh, sure. It
Yeah.
has its own time.
Because
Sure.
it's a vast topic. It will take some time for him to complete.
Uh-huh.
So now it is 15. So we can wait for some time and we can start.
Oh, sure.
Okay.
Okay, proceed. Proceed,
All
Vijay.
right.
Hello.
Hello. Can you hear me?
Yes, sir, you're
Yes,
audible.
I can
Yes,
hear
yes,
you. Okay,
you're
yes. But I can't see you. That's all.
Okay.
Sir, now we have 22 participants. We can wait for 5 more minutes and start the program.
Okay. Okay.
Yeah, now I can see you.
Sir, we can start the program.
Okay.
I request our President Philip Matthews sir to welcome our speaker of the day, Mr. Sankar Panikkar.
Good evening, ladies and gentlemen. Today I am chairing the meeting from a distance. That is in Australia, where the time is now 6:35. And I cannot see the participants, but I think we have got sufficient participants, maybe more than 25 now already joined. I think so.
Have now 35.
35, very good. So as a part of the professional development program, NCLT Kochi Bar Association intends to conduct regular programs which will enable its members to enlighten themselves in the various fields under the Companies Act and IBC, which they will have to deal with before the National Company Law Tribunal and National Company Law Appellate Tribunal and the Supreme Court. Today's topic is liquidation under the Companies Act and IBC 2016. That is a very relevant topic where the practitioners have to enrich themselves and update themselves. And professional development programs like this will help a lot for that purpose. And as you know, there are provisions for liquidation both under the Companies Act and IBC. Earlier, under the Companies Act 1956, both creditors and shareholders, registrar of companies, central government, all will have to invoke the provisions under the Companies Act 1956 to wind up a company leading to liquidation and dissolution. But here, now the creditors have been totally taken out from the purview of the Companies Act 2013 when the IBC was brought in, and suitable amendments were brought in section 272 of the Companies Act. Now the creditor cannot approach the NCLT for winding up a company, but if a creditor satisfies certain qualifications, threshold qualifications like 1 crore, he can approach the NCLT, but under a different route, that's IBC, Insolvency Bankruptcy Court 2016. And there are several provisions which today's learned speaker will be addressing it. For example, under the Companies Act also, there are several provisions for dissolution of the company. One is striking off under 248 of the Companies Act, where the registrar can strike off it, or the company itself can go for a voluntary striking off. And dissolution of a company takes place under merger and amalgamation also. That is under section 230, with section 232 and 233 of the Companies Act, where the amalgamating company, that is the transferor company, gets amalgamated with the transferee company, that is the amalgamated company, where also the dissolution takes place. And there is a provision for summary liquidation also under section 361. The members usually approach the NCLT under section 272 of the Companies Act for the if 271 is grounds under 271 is satisfied. And in the case of the Insolvency and Bankruptcy Court, the first attempt is to revive the company by way of a resolution process. If that process fails or the resolution plan doesn't take place, then the liquidation process starts under section 33 and culminates in the dissolution of the corporate debtor under section 54 of the Company Insolvency and Bankruptcy Code. And for that, the liquidator will have to make an application to the adjudicating authority, which is NCLT. Once the assets have been liquidated, using the waterfall mechanism under Section 53 of the Companies Act, IBC. In the same way, there is a provision for a voluntary dissolution of the corporate person. In other sections, the corporate debtor is used. Here, it is not by way of a default. You are taking action against the corporate entity, but a voluntary liquidation by the company, where the corporate debtor is shown as the corporate person. And many reasons, for example, the company is formed for a particular object, and that was not that has been accomplished, or it is not viable to continue the company. In such cases, voluntary liquidation under Section 59 by a corporate person is possible, but very rarely it is being resorted to. So all these factors have to be brought in when a liquidation process has to start. Either you have to go under the Companies Act if you are a member, or authority coming under the Companies Act, or if you are a creditor, you will have to go under the Insolvency and Bankruptcy Code. These are the highlights of the two enactments. And IBC, as you know, is being updated. Certain amendments are being brought in, and certain provisions have been repealed. The process is going on because it's still in the nascent stage. That is why. And we have got a very eminent speaker today to speak on the subject, who is none other than Mr. Sankar Panikkar. He is a practicing advocate in Cochin, and besides, he is an advocate. He is a cost and management accountant, and he is an insolvency professional with registered with IBBI, and he is the first NCLT appointed insolvency resolution professional and liquidator in Kerala. He has conducted many insolvency cases, and also many cases under the Companies Act coming under operation mismanagement, all such cases also. And he is also very competent to speak on the liquidation, both under the Companies Act as well as under the Insolvency and Bankruptcy Code. And he is currently the chairman of the Kerala Insolvency Professional Forum. And he was, in the previous year, chairman of the Southern India Regional Council of ICMAI, that is the Cost and Management Institute of Cost and Management Accountants of India. And he is a member of the Board of Studies at the School of Legal Studies at Cochin University. And he is currently a fellow member of the Institute of Cost and Management Accountants. And he is certified in commercial arbitration and mediation. He handles various commercial litigations, corporate litigations, and he provides legal opinion. He conducts due diligence, offers training in legal subjects, finance, and management. He imparts management training also, and he is a multifaceted personality who is capable of dealing with several subjects, and he has got a wide experience. And a very few of us know that he is an experienced banker also. That makes him a perfect speaker to speak on Insolvency and Bankruptcy Code. So we are fortunate enough to get him today as the main speaker, and we are eagerly waiting to enrich ourselves by his speech, which I hope that will be enlightening and informative to all of our members. With these starting remarks, I invite the main speaker, that is the keynote, to make the keynote address, that is on liquidation under Companies Act and IBC, Mr. SANKAR P PANICKAR. Thank you.
Thank you, Philip sir. You don't know how you have, inspired me when Cochin NCLT branch was open, bench was open. Hardly very few, lawyers from High Court used to visit, and you are one of the regular visitors. You have inspired me a lot. So therefore, thanks to you, and thanks for the kind words. Bijoy, can we start the presentation right away, or is there any other thing, or like just start off?
Yeah, you can start straight away because the time is a constraint.
All right, great. So I see the attendees, participants, and I recognize the presence of Shivakumar sir, Jinan sir, a lot of my friends. I'm not mentioning each one of them. Almost 80% I know. Therefore, there are a lot of common people in the Kerala Insolvency Professional Forum also. So therefore, I'm not mentioning anyone, but then certain people you just cannot miss. So Jinan sir, good afternoon to you. I hope you are in India. Like, I'm not sure whether he's in, Philip sir is in Australia. Normally, if you don't get to see Jinan sir here, he'll be ideally very safe in United States. I'm not sure where he is now.
Yes, sir. I'm very, very eager to hear you, sir. Good.
Thank you. Friends, I'll quickly go into the topic now. Thank you, Bijoy and Priya, for giving me this opportunity. I clearly remember the day when you called whether we can have a session, but I never thought that this is such a big, session. The participants are so learned that you get jittery, and then you get a little, whether a presentation will be good enough or not. But then I'll try. But then what happens is you have a PDF. Since you're working on a computer and you have the support of Companies Act and all those things online, soft copy, you can always give it a shot. So friends, with a small thing, I'll just start off. So first of all, let me say that there is a small, we need to understand the difference between liquidation, winding up, and dissolution. So liquidation basically is a process. Winding up is the function. And the end of the winding up, we'll end up in a dissolution of the company. When you have Philip sir as a initial welcome or pre-launch, you have you need not worry about the basic structure which you're going to discuss today. Thank you so much, Philip sir, for giving me a wonderful, in a 5 minutes, you have touched upon the most important things. So I will not repeat those things. So I'll just quickly move to the topics today. So friends, what happens in Indian law when it comes to winding up, as Philip sir said, there are two laws basically, Companies Act as well as Insolvency Bankruptcy Code. So insolvency, how you should appreciate this particular thing, according to me, is you have to go through the Act specific sections and also the rules. When it comes to IBC, we are supposed to know the regulations and adjudicating rules. So when it comes to Companies Act, it starts with 270 to 365. Actually, it has taken care of a lot of things, taken certain things from 1956 Act. And of course, you have to read winding up rules. So one thing which I have decided is I will not, fall too much on my memory, because every time 6 months or 3 months, you end up in seeing an amendment in insolvency regulations or rules or even sections of IBC. It continuously gets amended. So therefore, maybe 4 years before, I thought I had a reasonable grip over the subject. Now I will never claim that. The way the judicial pronouncements, the way it is evolved, is far beyond comparison. So therefore, when it comes to Companies Act, section part, chapter 20 talks about 4 parts. It talks about winding up by the tribunal, voluntary, And that particular thing, when you go through the Companies Act, the entire voluntary winding up has been omitted. And the provisions for every mode of winding up and official liquidate. Then there are two sections under IBC. IBC, as Sir said before, the intent of IBC is for resolution, not recovery. Time-bound program, time-bound processes, and of course 180, they can always stretch to another 90 days. Again, if it is required, adjudicating authority can give another 60 days. Be it as it may, but then if you look at the number, the statistics published by IBBI, it goes to more than 3 years in certain cases. Now, every day, some judgment or other comes up. For example, yesterday I came to know that NCLAT says, in one case, commercial wisdom of the committee of creditors says it should not go for liquidation. Then NCLT says, no, time has come, so we have to liquidate. So there is only very little scope for the judiciary or the adjudicating authority to interfere into the commercial wisdom of committee of creditors. Commercial wisdom as such, you will not get to read that term in the IBC, but then it is coined by retired Justice Rohinton Nariman. So commercial wisdom is something only that's enjoyed only by the committee of creditors. Whereas, what is the role of adjudicating authority? Go through the provisions and see whether any of the provisions, any of these things are, contradicting to the law. So that is a very thin scope for adjudicating authority in IBC. But then, if you look through the provisions, section 60, subsection 5, or NCLT 11, rule number 11, all those things give a little leverage for adjudicating authority to, support the system. So with that, I'll just start off. So liquidation, there are two types of liquidation, friends. Number one is liquidation, the typical liquidation of a company where there is no resolution coming up with, during the CIRP. There is corporate insolvency resolution process. If there is no resolution coming up, or else committee of creditors decides, will not go into the entire process, there is no point in continuing this process. Let's quickly go into the liquidation. That is also possible. So that is the creditors route. As Philip sir said, since there is no route for the creditors to come, earlier there was, in 1956 Act, there was a provision for the creditors to seek for a winding up. But then here, that is taken over by the IBC under section 7 and section 9. And of course, section 10 gives the corporate debtor to go before the NCLT and say, look, I've got default more than 1 crore. Why can't you put me into the CIRP? That is section 10. Corporate, they themselves go for as an applicant. Now, that is not how, if in the event the corporate resolution process fails, it goes to liquidation. That is coming under section 33. Again, when I started off this particular thing, this liquidation, for example, in 2017 to 2019, or maybe early 2020s, there were no much, I'm not saying no focus, I'm saying there were no much focus on the liquidation, because it was just picking up. CIP was just picking up. Now there are a lot of, focus being brought into the liquidation. And one of them is, court says that liquidation has to be done as a going concern. You should not try to kill the company, because if you look at the objective of the IBC, it never talks about liquidation. It never talks about recovery. It talks about only resolution. Therefore, in the event when it is, when it is put to liquidation, the stakeholders consultation company ought to see whether there is any opportunity for conducting the liquidation as a going concern. And there comes the interplay of IBC and Companies Act. Why do you say like that? Because section 230, talking about mergers, arrangements, compromise, and all those things. Do we get all those benefits? Do we get all those benefits that a person or a resolution applicant ought to have got under resolution process during this liquidation process? I have seen cases where the compromise and all those things enjoying the benefit of certain, waivers and other things. So to put it in a different way, during the CIRP process, when the resolution plan says that these are the things, resolution applicant comes and says that, look, I'm submitting this resolution plan with these provisions, compulsory provisions, and I don't want to take up these liabilities. And assuming committee of creditors gives 66% and gets the approval of NCLT, that is going to be the Bible. Likewise, in the case of liquidation also, when it comes to the early period of liquidation, that is within 90 days, if at all a plan comes, liquidation as a going concern, if at all some good things come, stakeholders consultation committee will definitely work on that. And of course, National Company Law Tribunal, being the adjudicating authority, can work on approving that thing. So that's, according to me, it's a very, actually it is developing. So with that, I'll just quickly move to the next slide, which is talking about the process. So section 271 says that, modes of winding up. Actually, there are 5 through resolution in the company. Then company acts against the, interest and sovereignty of India. It is being done in a fraudulent manner, or as Sir said, if at all they've, defaulted in filing certain forms or annual returns. Why is this? And of course, the last one, just and equitable. The 4th point is something very, very interesting. Why should a company be wound up if no filings is done on a regular basis? Every 5 years, every year actually, if there is a default in filing the terms, ROC will, registrar of companies will follow a process, and they will, strike off this company. The intent is something like this. Company is a separate legal entity. If it is not properly filing the returns, you never know what is happening to the company. And as a regulator, they have a responsibility. And you never know who is going to misuse this entire thing. I have personally come across during my stint in the banking, a lot of people misuse the company outfit. So this is a sort of, according to me, a sort of, deterrent or keeping safe, so that you don't misuse. And of course, if it is, if there are areas where you can go back to appeal under section 59, I guess, 252, where you can try your luck with NCLT and see whether it can be brought back. So what is the difference between, this is something which I'm sure, we should know. It is something like this. All of us know everything, but it is always good to read once in a while as to basics. This is the difference between what happens, and whenever we get certain questions, or whenever certain points are discussed before the tribunals or even court of law, certain basic things will always, I've always found that certain things can, our submissions can bring a little bit, declog the mind of, learned justice there. Therefore, this is something which I've always found, that the difference between winding up and dissolution. So winding up is basically the method by which dissolution is brought about. So this process has to be followed up. So at certain times, people use the word liquidation, certain times winding up, and all those things. And what is the ultimate thing? That is once the winding up is through, dissolution happens. What happens after dissolution? The company says, company cease to exist. Then the legal entity of the company continues at the commencement of winding up. That's the beauty of it. See, during the winding up process, doesn't mean that company is shut. No, company is still there. Liquidator will be there. He has to manage the affairs of the company. He has to manage that, so take care of the assets of the company. Therefore, the company maintains the legal entity. That's extremely important. For example, you can always expect certain litigations or some cases or proceedings against you during this liquidation proceedings or winding up proceedings. But whereas in the case of dissolution, it's bringing to an end to the legal entity. And the third difference, according to me, the company may be allowed to continue its business so far as necessary for the beneficial winding up of the company. I think it was, I forgot the name of the case law, where first the concept of liquidation as a going concern. I tried my level best to read the entire thing. I never had the, that imagination to see, being very honest to all of you, I never had the imagination to see how this company can be sold as a going concern or liquidated as a going concern. Then I have seen for myself that it will be liquidated, but then as a going concern. So some going concern will be there so that you can beneficially, it is in the interest so that cost is reduced, so that you can exhibit that, look, the company is being liquidated and company can be taken over. So the moment the word liquidation, you get the feeling that you are bringing down the machinery, you are, stopping the activity. It necessarily not like that. Not everybody, every occasions it happens like that. Like this, they will probably bring down the business. They may not stock, they may not add the inventory, but then they will just for the maintaining, for example, some service rendering or some sort of production, some sort of subcontracting, all those things happen during the liquidation. Possible, it's possible. And that will show that, look, a prospective buyer or prospective person who wants to take the company with the, assets, inventory, can look at this part. And company, when it comes to dissolution, stop. Company ceases to exist. Now, what happens here is when it comes to liquidation, there are two things. Number one, the first stage where a provisional liquidator is appointed, then he takes over as a company liquidator. So there is a winding up committee, and we'll go through that a little later. There's a winding up committee, and that winding up committee, you need to have a provisional liquidator, secured creditor, and official liquidator, and a professional to help the liquidator. Look, what is the intent of bringing that official liquidator? Basically, what we were thinking of is, look, when it comes to liquidator, a government person. Now, according to the law, they say the persons who have passed this examination, this insolvency examination, IPs, registered IPs can work, should work, can be appointed as a provisional liquidator, should be appointed or shall be appointed as a provisional liquidator. And in a committee, which is called winding up committee, the presence of official liquidator is must. According to me, I was thinking, what is the reason? What could be the reason for bringing that person? Anyway, you say that on one hand, you say that, provisional liquidator has to be an IP, or a company liquidator has to be an IP. On the other side, you are bringing the official liquidator also into the loop. Subject to the confirmation of all the learned participants here, I feel that when the company got into existence, you had ROC. ROC had given you the birth of the company. Now that it is being, sort of dissolved, you need to have an official person. That could be the reason, I don't know, subject to action. This is the basic section, friends. This is the basic section 271. It says that company may, on a petition under section 272, be wound up by the tribunal. So who has the authority to wound up the company? Tribunal, adjudicating authority, tribunal. So there are certain conditions. It starts with the, if the company, by a resolution, the company decides like, look, this is a special resolution. We resolve the company, resolve that the company will be wound up. So tribunal will not have much of a say. Tribunal probably would seek some more information whether there is any hidden agenda for dissolving the company suddenly, or may ask for certain details, may ask for certain data, balance sheets or resolutions. End of the day, when it comes to a resolution, normally tribunal is okay, but then they will always look at the regulators or even get a report from the registrar of companies. That is also possible. The second condition is if the company has acted against the interest and sovereignty of the integrity of India, security of the state, friendly relations of foreign states, public order, decency, and morality. Very, very wide powers. Basically, it is to ensure that we should not step our, act in such a way which is against the country. Third is registrar of companies or any person authorized by the central government by notification under this act. The tribunal is of the opinion. So basically, registrar triggers and tribunal is of the opinion that the affairs of the company has been conducted in a fraudulent manner, and or the company was formed for a fraudulent or unlawful purpose. Look how they have interpreted this. Formed, conducted in a fraudulent manner, formed for, fraudulent purpose, or the person concerned in the formation or management of the company. Formation and also currently management of these assets have been guilty of fraud, misfeasance, or misconduct in connection therewith, and it is proper that a company be wound up. Look, friends, I'll take 1 minute this here. I have seen a lot of cases where 447, 448 has been, alleged. What is going to happen in such cases? Investigation coupled with 230 investigation can happen. Some report can come. It actually enables this particular registrar to take an action. Of course, opportunity will be heard, but then end of the day, definitely looking into the perspective of the members also. Recently, I've come across a case where a big company have given a lot of money to a real estate company here, and they have found out that there was a fraud case. And of course, CIRP was initiated, solution has come, but then again, the financial creditor, financial institutional investor was trying at, they have appointed a forensic auditor themselves, not the CIRP. During the CIRP period, there was a forensic auditor, but then again, they have triggered a, forensic auditor, and you never know what is going to happen. But the problem here in this case, the case which I am referring here is, there is a resolution. Now, the financial institution has done, is getting concluded, a forensic audit. What will happen if the forensic audit initiated by the financial institution finds that this particular company was, was doing some fraudulent business? It's very interesting. Why? Because it's very, very clear that once a resolution is passed, it will prevail. And assuming the company was was conducting in a fraudulent manner, the promoters will be in trouble. That's what I guess. Anyway, it's too early to get judged now, but a lot of interesting things are happening. And the fourth point, that is, if the company has made a default in filing with the registrar, a lot of things are happening, friends, especially in the case of, let me just read this entire word, then I'll come back to the example. If the company has made a default in filing with the registrar its financial statements or annual returns. So financial statements, meaning all of us know, audited balance sheet or profit and loss account, in a statement of profit and loss account, note, schedules and everything, or annual returns for immediately preceding 5 consecutive years. In a case where Philip sir and me was arguing against, this is a case he was trying to very cleverly defend, his client to save a huge money, and there was no filing of returns. And it has gone to some other court, but then what happens is they have to follow, a registrar has to follow the process laid down. Addresses has to be correct, persons have to be correct. And all of us know how our ROC is functioning. Very, very difficult. I really, really feel helpless, empathetic for them, the way they've been, loaded with the work. And of course, what common is the internet connection or the website of both all the regulators, be it MCA or the income tax. It is just like a snail. All right. So registrar can say, look, this is a company who have been irregular in filing the returns or annual statements or financial statements being, wound up. And again, this is just an equitable that the company should be wound up. The tribunal says that if there is a deadlock between directors, there is no future prospects. Nobody is interested in taking either one of the group should take over the company. Neither they are interested. So it is better, though it is not in the good interest of the company, but there is no other option but on a just and equitable case. So look at these words being used here, just and equitable. Now, do you think that NCLT has an equity jurisdiction? No. But here in this particular section, the code says the Companies Act says if the NCLT feels that okay, it is just and disputable that the company should be wound up, it may do so. So this is a very I have seen a couple of cases in NCLT Kochi where it has been led to these cases, and a very funny case where there was a deadlock and tribunal has decided to wind up, go for this appointing a provisional liquidator. Suddenly, provisional liquidator pops up and says, look, there are certain assets. He is not giving me back the assets. And what is happening? And suddenly the person who has triggered this company petition says that, look, that was fraudulently done. That's fraudulently done. Please recall the order, review the order, all those things. It is not decided. Very interesting case. And again, 272, it talks about subject to the provision of this section, a petition to the tribunal for the winding of the company shall be present. So on whose application, tribunal can act? Number one, the company, contributory or contributories, or any of the person in A and B, registrar and the central government, and of course, central government or the state government. Basically, company, contributory, registrar, or any person from the central government can trigger this application. So basically what happens here is he may, by the holder of fully paid up, a contributor. So contributor is a person who has paid up to the equity capital, shall be entitled to present a petition for the winding of the company, notwithstanding, he may be the holder of the fully paid equity shares, or that the company may have no assets. So let us not have a confusion whether or see assets. We should not actually link it with the assets of the company. If there are no assets of the company, whether it can be wound up, all these questions can pop up. So the section is very clear. He may be the holder of fully paid up shares, or the company may have no assets at all, or may have no surplus assets left for distribution among the shareholders after satisfaction of liability. So therefore, there can be a situation where at the end of winding up, the contributory will not have anything. Still, it can go for it. That's the essence of it. And shares in respect of which he is a contributory, or some of them were either originally allotted to him or have been held by him and registered in his name for at least 6 months during the 18 months, immediately before the commencement. So basically, friends, the takeaway from this particular section is contributory can do that. The end result of winding up assets, no sufficient assets, or liability more than assets, or no surplus left for them, that's not the criteria. What about the registrar? Registrar shall be entitled to winding of the company, except on the ground specified. What is that ground? Ground is a special resolution resolved that the company be wound up. So that is a section 27A. So registrar can trigger an application other than the section 271A, which is other than a company's resolution, that is special resolution. The registrar can do that, provided he should get a prior sanction of central government. Typical, and there's nothing new about it. But then, unless we have to be from the perspective of a lawyer or a person getting a notice from registrar, we can always go through the notices carefully in such a way that always there should be a reference to the power from where he has got, based on which he is taking an action. Most probably, they will quote that. This is issued based on that section or this section. I'll tell you a classic case where in the Income Tax Act, this particular power is given to assistant commissioner or the persons given. So basically, that is the intent. So central government, for the easiness of execution of their orders, they can give powers to others. So that is the reason which is given. Powers sanction of the previous sanction. So it's not like later on. No, the previous sanction ought to be there. Then government shall. So they're provided that the central government shall not. So there are instances where central government shall not give accord unless the company should be given an opportunity. Here also, assuming there is nothing new about for people into the legal profession that unless you are not heard, you can always go to the High Court and go for a stay. But here the act is very clear. You can, registrar can do that, but then give an opportunity for a company. Fourth point, petition presented by the company for winding up before the tribunal shall be admitted. It talks about not shall, it is mandatory, shall be admitted only if accompanied by the statement of affairs. What is statement of affairs? All of us know. What is the position of the assets and liability of the company? Why are we not using the balance sheet? Balance sheet is talking about a different thing. Statement of affairs is something talking about the liquidation. In such form and in such manner as may be prescribed. A copy of the petition made under this section shall also be filed by the registrar, and registrar shall, without prejudice to any of the person, submit his views to the tribunal within 60 days. Now, what happens here in this? Let me explain to you the practical thing. The moment you cause a petition or file a petition before the tribunal, invariably tribunal will ask whether have you kept registrar a copy or did you get the report? So when it comes to typical, striking off, all of us know we'll serve a copy, get the report, and within 60 days they give it. Or tribunal is so kind enough or generous when it comes to AOs, ROCs, where they'll be given additional time for filing this. So my view is registrar, will be having a say. That's what I'm trying to say, and tribunal will definitely, invariably, tribunal will look into the views of the regulator, that is ROC. And 273 talks about, there are red columns I've just highlighted so that you can read that. What will tribunal do after how will they dispose it actually? No, this is tribunal may, on receipt of the petition of the 272 may. What are they doing? What are the options before them? Dismiss it with or without cost, make an interim order, or appoint a provisional liquidator. Provisional liquidator basically acts as provisional liquidator or company liquidator. Basically, he collates the data, he collates the information, assets, control over the assets, and he gives a report. And always in the greatness about company the winding up rules is such that you get about 20 forms. Everything is in forms, be it the application, everything is in forms. WIN forms, winding up, short form of winding up. So everything is in WIN forms. So therefore, it is not like you need not write in chaste English or something. You need to just fill up the forms and put it in a template thing and file it. And provisional liquidator also have to report on a monthly basis before the tribunal. Why does this happen, friends? We should always ask why this is being asked. We might see that this is a laborious process for a liquidator, for a company who is not making any money. But then again, the liquidator is being asked to file a report. Every time you file a report, you have to pay 1,000 rupees and also a few administrative costs, out-of-pocket expenses. And of course, if at all you are engaging a lawyer, of course, his fees have to be paid. A lot of things. So the question is, tribunal is empowered to see that, look, the procedure is being followed. There is no hanky-panky. There is no fraudulent transaction. This is the intent. Sankalpam adana. That is the noble, belief that this is a noble thought for doing, according to me. Then what happens is make an order. Tribunal can make an order for winding up the company with or without costs. Then any other thing which they think fit. They can, no, it's not going to be possible. Charges, anything can be. And they can even say that if it is there's a chance of mediation, you can even think of that. So certain adjudicating authority, certain learned members always look forward for a solution rather than killing the company. So that is an area here, provided that order under this section shall be made within 90 days. Friends, we'll get to see a lot of numbers, 90, 60, 45, all those things in Companies Act and IBC. For IBC, it is full of numbers and that target dates, but doesn't matter. there are several judgments which says that it is just directory. But then you cannot just claim that as a right which you have. Look, it is just a directory, I forgot. It doesn't happen like that. So there should be an intent from the side of the persons who are applying, or even a resolution professional or a liquidator, that there was sufficient reason for me not to comply with the orders. So that is it. So that timelines are directory only, even if they use the word shall. Surendra Trading Corporation case law. Provided that before appointing provisional liquidator under clause C, tribunal shall give an opportunity notice to the company and afford reasons. All those things, typically, audi partum, there is natural justice. Provided, this is something very important. I would want you to just, be careful, little bit careful here. Tribunal shall not refuse to make a winding up on the ground only that the assets of the company have been mortgaged for a amount equal to or in excess of the assets, or that the company has no assets. So these three things: liability more than assets, no assets, or it is mortgaged. This should not be the reason for not putting it to liquidation. So what happens like that? As I told you before, contributory may not get a surplus. The secured creditors or the creditors may not get their value back. But end of the day, if other things being complied with, tribunal will naturally order for liquidation. Where a petition is presented on the ground that it is just and equitable, the company should be wound up. And the last, the power which the tribunal enjoys, tribunal may refuse. Look at that. These are contradicting. May refuse to make an order of winding up if it is of the opinion that some other remedy is available to the petitioner and that they are acting unreasonably in seeking to have company wound up instead of pursuing other remedy. So one thing should be very clear when it comes to, for a minute I was just thinking about what will tribunal think when a case is before them, as they know that company is doing well. It's just between a dispute. I'm using the word dispute between a set of shareholders, another group of shareholders, and the tribunal is reasonably convinced that there is a business in this company. Company is there. Company's assets are there. It is just a silly. There could be a silly, a reason for them to be before the company. Of course, I'm not using the word silly asset, but then assuming tribunal has that mindset, then they can refuse it. Tribunal may refuse. It's not shall, may refuse to make an order if it is opinion that some remedies are available. What could be the remedy? It could be like one group taking over the company by, valuing the shares, or some mediation, or based on some intervention. Somebody has said that, look, give me some more time. I will sit with the banker and find out a solution. I'll buy it. Anything is possible. I'm just giving a wild thought. I'm sorry, friends, this is a little bit of, there is no, when it comes to law, we cannot just, ignore quoting the section because I don't want to be in the wrong foot. When a petition is winding up, when petition for winding up is filed with the tribunal by any person other than company. So winding up can be done by any person, and application can be done by any person. So what are the precautions a tribunal has to take? Other than the tribunal shall, if satisfied that a prima facie case of winding up is made out, direct the company to file its observation. So basically, any person. So if any person is before the tribunal and say, look, this company should be wound up because these reasons, then the courts, the act says, company should be given an opportunity. Provided that tribunal may allow further period. So days will be given, all those things, special circumstances. Basically, these are all things which the tribunal has got the power. Company which fails to file, company which fails, company which file a statement of affairs as referred to shall forfeit the right to oppose the petition, and an officer found responsible. So basically what happens here, friends, is statement of affairs is a compulsory thing. If the company fails to do that, it shall be forfeited. And of course, what I'm trying to say is, in that case, directors and officers of the company as found responsible for such non-compliance shall be liable. So statement of affairs has to be given, and in such case, if it is not given, the promoters or the directors will be held responsible. That is what it says. Directors and other officers of the company in respect of which order for winding up is passed by terminal under clause D of 2% shall within a period of 30 days submit at the cost of the company books of accounts. So now what happens in my cases, couple of cases, tribunal has director for winding up. Directors are still fighting. Directors doesn't, or the shareholders doesn't look at each other. Now, that will come to a situation where the provisional liquidator or liquidator will not be able to perform their, duties. So, again, he can come back. He can come back to tribunal and say, look, they are not giving. All those things, it's possible. Director or officer of the company contravenes of the provision, imprisonment. So, basically, 274.3 is like the officers, the directors are supposed to, once the admission or liquidation has been ordered, then all of them should, support or give details to the liquidator. Liquidator can be a stranger. He may not even know the business. He may not be even a technocrat. He may not be knowing how this business is done. I mean, he should get information from these people. It is akin to, if he is not getting any information, he can, typical of section 92 of IBC, he can approach court for getting support of that. And of course, these people will be punished if they don't, directors don't support the process. Now, coming back to liquidation process. Liquidation, I said, it is like this. Liquidation, as I told before, the end result of not having a resolution, that is liquidation under section 33, and the company decides, they in a general meeting, they call up and say that, look, the assets of the company is more than the liability. This particular instance is not for defrauding anyone. Let us voluntarily wind up. That is something like section 59. The beauty of section 59 is such that most of the sections, if you go through the IBC, now it is an insolvency bankruptcy code. It's not act, it's code. Most of the provisions of 33 would be, that is the normal liquidation will apply to voluntary liquidation. Only thing is, when it comes to voluntary, you're no more talking about stakeholders consultation committee. It's talking about contributory. So, coming back to the winding up, a little bit of rules. Friends, this particular company winding up rules 2020, it's a very big file, okay, about 125. I was just counting the numbers of pages, 125 pages, a lot of sections, 250 or something like that. Sorry, 130 or something like that. It talks about, it takes care of everything, very, very lengthy. And after that, they're giving a lot of forms, win forms. So, why those win forms have been given? I think it is maybe ease of doing. You do not, the petitions or can be as brief as possible. Just to take you about the recent development which has happened in insolvency bankruptcy code, where the liquidation progress reports, and previously there was no liquidation, formats for liquidation. When I was handling this liquidation, we used to download the specific sections and keep that as in my case, keep that as a heading and write down in a paragraph as what has happened in the last quarter. And again, I will add the next quarter. So when it started, it was roughly about 4 or 5 pages, because no major things will happen in the first quarter other than claims verification. Other than, by the time my liquidation got over, it went up to about 70, 75 pages. So what has happened in the case of IBC latest liquidation, this thing is they have come up with a format, okay, a template. Actually, that is good. Basically, content has not changed, but then they have, they have given which according to me is good, because end of the day, there's a huge scope for subjectivity when it comes to interpreting a section by few people. So end of the day, if you're talking about IBC, it's very, very objective code. So very, 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 very focused code. Therefore, good that IBBA has come up with that. So that is, I'll come back to this. So when it comes to winding up, tribunal makes an order for the winding of the company. It may in 7 days cause intimation liquidator and registrar. So registrar here means, registrar of companies. When the registrar receives the order, he makes an endorsement in his record, notified gazette, and intimates stock when it comes to listed company. Winding up order will be deemed to be the notice of discharge of officers, employees of the company. This is same. Within 3 weeks of winding up order, winding up committee to be formed by official liquidator. Basically, provisional liquidator, I meant. So what is this winding up committee? This is a new concept according to me. It is basically look at the left side column, the left side box, official liquidator. As I mentioned before, the presence of official liquidator is extremely needed. We might feel that no, this getting process is complicated. No, he might be busy. He might have thousands of issues before him, but then he's an official. He's an officer of the regulator or the government. So he ought to be there. Because if ROC is the person who has signed the certificate of incorporation, this person is to be in loop. Had it not been IBC, he would have done the entire process. And we have come across several cases where official liquidators are not able to perform their job because of the multiplicity of work, not having enough infrastructure, not having people to do. In years before this IT onslaught, everything was in papers. You don't have the documentations. Very difficult. So I think this is a good thing, at least some positive thing. And look at the second point, friends. This is about secured creditors, nominee of the secured creditors. You're right. There is no unsecured creditors. For example, there is a company where the entire asset has been liquidated by the secured creditors and they've gone off. They'll be creditorless. Even if some, unsecured creditors, still they will not have any nomination in the winding up committee. And a professional nominated by the tribunal. Basically, it can be like a person who has got some experience in similar industry or a finance professional or legal professional, basically to help the professional liquidator. So what is their job actually? Their job is to take over the assets, examination of the statement of affairs. The statement of affairs is something the company has to give. Most of the cases which are in liquidation, you never have an idea. They will not have books of accounts. I'm talking about a typical case where I'm handling, no idea, changing the, it's just like blame game happening. And recovery of the property, cash, or other assets of the company, including benefits derived. For example, there will be some litigations, some arbitration pending, or some action ought to be taken to get that, claim or something like that. These people will have to take care. Review of audit reports, accounts of the company, sale of assets, then finalize a list of creditors and contributories. So once these things happen, you can finalize who all are the contributories, who all are the creditors. You get an idea as to what is the position, what is the state of affairs of the company, what is the list, what is the total liability. What could be the proportion if at all some money is being realized. Then compromise, abandonment, settlement of claims. All those things, as I told you, in the liquidation, winding up rules, very elaborate they have given. Honestly, I just glanced through that and I thought it will take at least half a day or even a day to give you the entire idea about this particular thing. So I didn't venture into that, honestly. Then how do you pay the dividends? Assuming you realize X rupees, you give off, you take care of the cost and what is left out and what will be the dividend percentage, basically a proportion. Any other functions required by the tribunal. So tribunal can say, look, you have to do these things. If you ask me, tribunal can, based on the facts of the case, based on the pleadings, based on the specific requirements of a party, can definitely assign certain things. For example, assuming the company is having a specific asset which ought to be liquidated immediately, maybe perishable or something like that, court may say, look, please give a report as to what is that. It's a very, assuming there is a particular inventory is a chemical which has got, you need to have a license for that. So it's holding of that requires special license. I'm talking about, firecrackers and all those things. The chemicals for manufacturing those things can happen. It can happen. So these are the areas where tribunal can just chip in and say, look, you do this also. So winding up committee has to look into that also. So 275 and 277 talks about a little bit. Provisional liquidator is appointed before the winding of the company. So we have to be very careful, friends, here. In the code, in the act, it is said that company liquidator in the provisional liquidator also. So it is used interchangeably. So at places where you get to see the word company liquidator and also provisional liquidator. So both of them, let's put it like that, before the winding up process, provisional liquidator, and official company liquidator after the winding up order. Now, after provisional liquidator gives the details, company tribunal, company law, NCLT says, okay, we are convinced, we go for a winding up of the company. Once that order is done, then the provisional goes off and official will come. Company liquidator, the change, the name is, the position is changed to company liquidator. Provisional liquidator tribunal appointed by the tribunal following the insolvency. I told you, because after IBC was notified, this is being used. If the company is not the applicant, notice for appointment of PL given in the form Win 7. I'm not going to confuse you with numbers because I myself forgot after reading all those things. So certain things can be done only through Win forms, each and everything, lot of Win form. I'll try to take you through the binding up rules which I have downloaded and kept. Lot of forms. If the company is not the applicant, notice of appointment of provisional liquidator given to company in form Win S. Look, there is no template. There is a template, so you need not write in whichever way you want. So it's very simple. Restrictions and limitation imposed by the tribunal on such PL laid out as an order in form. So order has to be in Win 8. Company liquidator or a provisional liquidator may file a declaration in Win 10 regarding the clash of interest or on a confidentiality, assuming he was an auditor. If he's a chartered accountant, he had audited and he has to disclose that. All cost incurred by the provisional liquidator is to be paid out of the assets of the company. And if such assets are not there, this is a typical case, friends. Company will not have assets. Company will have some, books. Even books of account is a distant dream. I'm not talking about all the company. I'm talking about the companies normally, which is before the tribunal for a winding up. So tribunal will ask, what is the money, what is the assets, and all those things. There is no assets. I have not received my fees. Court will say, okay, pay this money as initial. Then you look at, and of course, the winding up committee can also. Look, there is later on there is an advisory committee coming in 287, section 287. So all those things with regard to the remuneration of the remuneration cost of the liquidation, tribunal has a say. Theory, simply put, it has to be from the assets of the company. If there are no sufficient assets, tribunal can direct. So what is this company? So now we have moved out from provisional liquidator to the company liquidator. What is his functions? What are his functions? Acts as the convener of the winding up committee. He shall play the tribunal minutes of the meeting, and it has to be reported. Then he has to give a final report. I stand corrected. This is this is the case where provisional liquidator and company liquidators mean frequently used interchangeably. Here, what happens is when it comes to final report for consideration, the approval of the winding up of committee. So, provisional liquidator will be, convening the chair, convening the meeting. Official liquidator will be a person, secured creditors representative, and also the professional. They will finalize the report that has to be given to the tribunal, and it's a responsibility of the company liquidator. Final report approved by the Vyniyam committee shall be submitted to by the liquidator before the tribunal by passing dissolution. So once the report is finalized and you give that, okay, all those divisions, dividends have been given, realization, distributions, paying of costs, settlement of cases, all those things, it is an ideal case of, typical case of dissolution. So that is also winding up committee's, responsibility. Company and a company liquidator may, with the sanction of tribunal, appoint one or more CAs, cost accountant, chartered company secretaries, or other professionals who assist them in winding up the company. So, report of the company liquidated. What are the contents? When it should be given? This is very important. So, contents of the report is very clear. Nature, amount of capital, existing or contingent liabilities, debts, subsisting contracts, holding of subsidiary companies, details of legal cases, any other information that tribunal directs. Friends, these are the areas where tribunal will put its mind and say that, look, why should you, why don't you look into these angles? We have come across several cases, not just Kochi, other Chennai, when I was, observing. Tribunal comes up with certain good suggestions, give an option and give an affidavit that what is the position now, bring the that particular person, requesting the presence of registrar of companies. A lot of things can happen. Power to carry on duties of the company liquidator, power to carry on the business of the company as being beneficial for winding up. So basically, as I told you before, company liquidator has to ensure that if it is possible to run through the company to ensure see that the company is running as a going concern, so that some beneficial things, for example, they don't allow it, assuming some inventory is there. That inventory can be put to some process and can be sold with some margin. He can be, he's empowered by the act to do that. All acts, name and behalf of the company and to use the company seal, sell whole company or the property of the company, raise money on the security of the assets, everything is possible. To institute or defend case, to invite and settle claims. Though it is written, institute and defend case, once the company is put to liquidation, no cases will lie, be it IBC or Companies Act. We can very well stop the proceedings against the company. And if at all somebody, so what is the logic? That's a question which we should address. Assuming there are cases before against the company is put to liquidation. You are saying that no cases will lie against the company. No further cases can be filed against the company. The logic is this, friends. When the company is put to liquidation and the tribunal has appointed a person who is an officer of court, if at all you are aggrieved by the, against the company's past deeds, you can always lodge a claim for the money. And assuming the liquidator do not agree or rejects your claim or dismisses or reduces your claim, then you can always go back to NCLT and say that, look, this is not possible. And he has unjustly, rejected or reduced my claim. That's possible. That is the legal thing. In the IBC or in the Companies Act, the liquidator has been given a quasi-judicial power. Not fully, quasi, little bit. He can look into the claim and see whether this is admissible or not. And if anybody is aggrieved, they can approach tribunal. So why the cases do not lie against the company? Because they can always claim before the tribunal, liquidator. And if the liquidator's action is not, if any person is aggrieved by the action of liquidator, then he can go and approach. So there is an alternate mechanism. Of course, there will be a lot of challenges. Just today morning, we have got a question whether there was a share transfer 4 years back. Where does the limitation, some fraud happen? All those things can happen. So the fact of the matter is liquidator is having a quasi-judicial power. Therefore, he can address certain issues that all the stakeholders come and claim before the liquidator. And if at all anybody is aggrieved, they can approach NCLT. That is the reason why no suit will lie against the company. Power or duty of the company liquidator. Sorry, did I miss out? No. Inspect the records, do rank and file, draw, accept, all those things. I will not take, it's typical, run through the company. Friends, this is a case of advisory committee, section 287. Tribunal may order that there shall be, tribunal may. So tribunal feels based on the facts of the case, based on the pleadings made, based on the winding up committee report or monthly report or something, this tribunal is of the particular tribunal is of view that, look, this is a complicated one. Let us have an advisory committee, assuming the stake is so much, a lot of employees, workers, disputes. So they can always have an advisory committee. Tribunal may order that there shall be an advisory committee to advise the company company liquidator. And he should to call meetings of creditors and contributories within 30 days. Members shall be, he shall be the chairman. Company liquidator will be the chairman. Not more than 12 members, including creditors, contributories, and such other members tribunal directs. So basically, as I told you, friends, looking into the magnitude of the case, and it seems that if it is observed, it is felt by the tribunal that, look, this requires some sort of experts in this issue or some more stakeholders to be brought in, meaning somebody's employees, creditors, then they can put all these things so that the combined wisdom can take you through the liquidation process smoothly. So what is the additional benefit? What is the additional, the powers which this advisory committee has? Look at the last point. Advisory committee can inspect books of accounts and other documents under liquidation. So this is a discretion of tribunal to appoint an advisory committee based on the facts and circumstances of the case, and they can even inspect the books of accounts. That may lead to some other conclusion also. We never know. Now, look at the various forms. I was just going through this. I mean, don't remember, friends. Never spend your time in remembering the numbers. It will not take you anywhere. By the time you remember, company law, the ministry will amend this. So let us not worry on such things. But then it is basically a format. Petition for winding up, affidavit format, statement of affairs format, advertisement which has to be given, appointment of provisional liquidator or company liquidator, appointment of all those things. And intimation sent by the registrar to the company or provisional liquidator, all those things. Look at that again. INC 28 is a common thing which we are normally filed by the company to inform ROC. Other than all this win is I've taken from the company rules of it. So official liquidator, what is his role? Official liquidator plays an advisory role, and that comprises of official liquidator, winding up company advisory role. For example, in one of the cases where I've seen official liquidator being a government official, typical of looking into the see whether all the stakeholders are interested are met. They may seek for additional information. They may go through the books of accounts and say that, look, this is why this liability is appearing here. Let us be very careful in such things, and let's bring all those people and see what is happening. Whether there is any wrong intention, look whether there is any dues towards the government regulators, be it in the form of taxation, indirect income tax or direct tax or whatever, or a PF. Also, basically, he's an advisor. He'll actually help the company liquidator to take the right route. He has been vested with the duty to monitor the company liquidation under the IBC is complying with 270 of the Companies Act. So not IBC, it's Companies Act. He shall maintain register and books of accounts in the manner specified. Company liquidator was vested with the powers. So what was the earlier position? In 1950s, official liquidator was vested with the powers of company liquidator. I mean, official liquidator. That's what I was trying to say. 1956, official liquidator was given a lot of power, and that has been taken to this company liquidator, wherein IP is taking care of that. All of us know how many cases are still in the high courts, typical of company law board times, then appeal with high court and other things. It's still there. Formerly, he was a custodian of company's property. Yeah, we have discussed that before. Now, friends, this is the Companies Act. I'll just quickly run through this. So there was a position where there was no resolution coming up in the insolvency proceeding. So we were looking at, before that, let me just 1 minute here. So far, we are discussing about the company liquidation, where the company tribunal acts, tribunal based on certain application or registrar of companies, or the tribunal themselves feel that, okay, just unequitable, they'll put a provisional liquidator, and a winding up committee takes over the assets of the company, and the liquidator will try to see that, look, the company can be run in such a way that not gainful, I'm not using the word gainful, just to ensure that liquidation process is smooth, some sort of going concern, so that it can be the prospective person can take over the in as his worries and run, he can take over the company as a running company. Everything is possible. Winding up committee can take certain calls, and of course, if it is so complicated, tribunal can appoint an advisory committee. Now we are slowly moving to IBC function. IBC, what is the I remember Phillips was saying about creditors. Creditors now cannot simply take the Companies Act route. They have to invariably take the IBC route. IBC route, Section 7, Section 9. Section 7 talks about financial creditors triggering an application. Section 9 talks about operational creditors triggering an application. The threshold limit is 1 crore. In the case of Section 7, there need to be answered only 3 things: debt more than 1 crore, default was there, and of course, with a limitation, whether the application is within the time limitation. Rest everything is a summary proceedings. It will just get admitted. And of course, there are cases where when it comes to admission, takes some time. But end of the day, most of it either get dismissed or disposal happens. What is Section 9 talking about? Section 9 talks about an application filed by an operational creditor. Who is an operational creditor? Operational creditor is a person who has provided goods, sold goods and not received the money, or rendered service for which no receipt. So he can approach, provided threshold level is 1 crore, default, limitation. Now, what is the catch when it comes to Section 9? There shall not be any dispute. There are umpteen number of cases where due to the reason that there was a dispute between a corporate debtor and the operational creditor, that was not admitted. Yeah, yesterday all of us know Byju's, have been put to liquid and corporate insolvency resolution process. I don't know how the transaction. I have not gone to the fine print of the judgment. Of course, I will just glance. If Byju says, the company says that it should be put to arbitration, then ought to be some dispute has to be there. I don't know. Let NCLAT take a decision. Had it been in Kochi, definitely it would have been High Court handling this tomorrow, maybe early moving or something like. Definitely, had it been in Kerala, writ petition miscellaneous would have happened tomorrow morning for sure. So Section 9, it goes interim resolution professional, and Section 10, friends, Section 10 about the corporate debtor himself says, look, I've got more than 1 crore. This is the latest balance sheet. Last day is just prepared within 14 days. We have resolved and approached this tribunal to put us to the corporate insolvency resolution process. Friends, in these 3 cases, assuming companies put to liquidation, again, I borrow the words of Phillips, corporate persons. That means company, LLP, not into the normal partnerships. So these 2 companies, assuming it is admitted, IRP will be appointed. After 30 days, within 30 days, he will verify and collect the claims. Within 30th day, he will form a committee of creditor. Same person or any other person will be appointed as a resolution professional. Resolution professional has to appoint certain professionals by way of the valuers. He has to prepare an information memorandum. He has to go for an expression of interest, and based on the information memorandum, prospects can come. They'll be shortlisted, They'll be given time to, submit their resolution plans. And in the event that is rejected, or in the event no resolution plan comes, liquidation will happen. So assuming the process goes through 180 days, and here the committee of creditors, that is, committee of creditors is a committee formed by the financial creditor. Financial creditor is a person who has given financial debt in return for the time value of money. So basically there should be a disbursement, there should be time value of money. Those people would be in the committee of creditors. They will decide the fate of the company. So there was a constitutional challenge in the Swiss ribbon case. Why only financial creditor is being put to the committee of creditors? So Justice Nariman says the interest of a financial creditor in the company and the operational creditor is different. Operational creditor, just like this, you give it or I lose. I don't have a permanent loyalty towards you. Whereas in the case of a financial creditor, according to Justice Nariman, there should be more than he walks along with the corporate debtor. Therefore, he should be given a say in the company's decision going forward, because he is like bank. When you appreciate the balance sheet, on the left hand side you will get to know the net worth. And just after that, you get to know the own funds and loan funds. So basically, these funds takes the company to to the next level, or moves the triggers the company to go further. So that is the reason. So committee of creditors decide that, look, the resolution should be passed or resolution to be rejected. Let's put it like that. That resolution is not acceptable to us. That's rejected. Let us put for liquidation in that way. Or else no resolution comes in the time period 180 or the additional 90 days or even the 330. No resolution comes. Automatic liquidation. Or the committee of creditors can say that there is no point in doing this raised exercise. Let us put it to the liquidation. I've seen a couple of cases. They will not even wait for 180 days. They can simply go for that. So look at this, friends. Section 33, where the tribunal does not receive a resolution plan, they either before expiry of the resolution plan or a fast track or resolution has been rejected, tribunal may pass a note to liquidate the company. And after liquidation, what happens? Public announcement happen. Liquidator will be appointed. And even, the order will be given to the ROC. All of us know. Now, what happens here in the case of liquidation is, I'll just take you through the liquidation another 2 minutes later. Liquidator comes here with a mandate to see that first 90 days to see whether the company is a possibility of company to be liquidated as a going concern. 90 days windows is given. Again, he has to go for expression of interest and all those things. Of course, at this point of time, instead of committee of creditors, they have got a group of people called stakeholders consulting committee. Friends, the difference between committee of creditors and stakeholders consultation, SCC, is simple. In the case of RP, a resolution process, a CIRP, committee of creditors, whatever they say, RP has to follow. And 66%, 90%, 50%, all those criteria are there for taking decisions. But in the case of stakeholders consulting committee, the liquidator need not necessarily follow the advice of stakeholders consultation committee. In such cases, what he has to do is to go to tribunal and say that, look, committee's decision is this. I am in totally opposite opinion. So please be informed. Not even prior approval. Hear it from your friends. Not even a prior approval. You have to just say, no, not prior approval. No, you need not get a direction from the tribunal saying that, look, I'm acting against, you give me an order. No, you are just to report to the tribunal that I'm going to act. Liquidator is going to act against the advice of stakeholders consultation committee. Now, the question normally has to be, how can they do that? How can they do that? How can, what is liquidator has such a power? Friends, the answer is very simple. What is the objective of code? Anyway, the value is getting deteriorated. So there has to be some sort of, urgency. And what happens typically in SEC is, the creditors who have given money with some security, naturally, practically, let me tell you what is happening. The lenders would have given a higher valuation. And when it come and given loan, And when it comes to liquidation, the liquidator's value will be terribly lesser. So there will be a clash. There will be a clash between the value of the value which this financial creditor has in his mind and the value which normal 90% of the cases the opinion differs in this area. So he goes ahead and does the liquidation. So I mean takes the decision according to, but he has to apply his mind. He has to apply his mind. He has to record the reason. The minutes have to be a speaking minutes according to me, so that let not anybody come and dance on his head later. So that is the liquidation in the typical normal liquidation model. This is that is section 33. And section 59 talks about voluntary liquidation. Voluntary liquidation, as I told you before, company says, no, we are not interested. Everything is over. The purpose for which the company is constituted or formed has been achieved. So therefore, we'll liquidate voluntarily. Or there is some sort of dispute among the shareholders saying that, look, I'm not interested. I don't want to take over this company. Neither I don't want to be a director. Later, I want to get back the money which I've invested. Some sort of stalemate. Neither they want to put that as a operation mismanagement, or some sort of a unique situation arises in such a way that voluntary liquidation is the best possible way. So what is the intent? Intent is it is not done for defrauding others, and the assets of the company is more than its liability. And one more thing, declaration of solvency comes with a clause saying that if at all, this thing, directors will be held responsible. Assuming some other liability pops up, then director has to pay from his pocket, as simple as that, in the worst instance. So another important point when it comes to voluntary liquidation is they have to take a as a registered value certificate. Why? Because to see that value of the asset is more than the liability. So assets is more than the liability, special resolution, and the registered value certification is must for a voluntary liquidation. So is there any default? Is there any default in the case of voluntary liquidation? Not necessary. In the case of ordinary liquidation, a typical other liquidation, default is a must, because then it has due to CIRP process, then to liquidation. So default is a germination or the trigger. In the case of voluntary liquidation, there need not be a default. So conditions I just mentioned, declaration of solvency, and that it is not meant for defrauding the creditors. And of course, what is the base on which you give a declaration of solvency? Balance sheets and an audited balance sheet, and as late as 14 days. And of course, the valuation of report on the valuation. So these are the two things, friends. 2013, inability to pay debts as a ground for winding up. 270 5 grounds. But when it comes to IBC, inability to pay debts completely on the ground of winding up, then 2 more grounds: inability to debts and voluntary winding up. So these are the 2 things. These are the comparison. And changes affected, 2016 voluntary winding up. Voluntary winding up to be carried out in a period of 12 months. It was 24 when I started off my practice in IP. Now it reduced to 12. Good for that. And consultation, stakeholders consultation committee is there. And now this is something, now it goes to, the process which I have mentioned. It's a very lengthy presentation. I'll just take a hold here. I'll just stop this function, stop sharing. Friends, the process of liquidation is a bit, laborious in such a way that I'll explain what is happening. The liquidator will be appointed. The latest regulation or the notification says that if a CIRP is not successful in getting a resolution, or company goes for a liquidation, then the same RP may not be appointed as a liquidator. That's the notification which has come from IBB and almost all the NCLT, according to my limited information. They change the resolution professional to another person to act as a liquidator. So what is his job? He has to first go for a public announcement, then go, in the case of CIRP, initial 14 days is the time period for giving submitting the claims. In the case of a liquidation, it is 30 days. In the case of CARP, the RP can admit the claim which is received by him up to 90 days. Beyond 90 days, he should reject it, and if at all the tribunal, the adjudicating authority feels perfect, he can accept it. So when you look at CIRP and liquidation, the claims has to be received within 30 days. He has to collate, he has to decide, he has to apply his mind. Some adjudication powers have been given to the liquidator. He'll prepare a he'll prepare a list of creditors, and of course, out of which he will take representative for the stakeholders consultation committee. And again, if he feels that there should be additional, what do you call it, the valuation report is to be taken, he has the powers to do that. And first 90 days, as I told you before, first 90 days, he has to wait for the, he has to give an expression of interest, saying that as a going concern, efforts have to be taken to see whether company can be liquidated as a going concern. As I told you, that is an instance where there will be an interplay between Companies Act and the Insolvency Bankruptcy Code. Again, the challenge which normally faces, look, during the CARP, you come up with a resolution plan which will prevail. Whereas the arrangement during the liquidation, it has to be so clearly mentioned in such a way that normally, why should somebody take over the entire liability during liquidation? So normally, assets will be there. Asset has to be there. Will be taken over by the person during the liquidation. Plus some sort of flexibility. In couple of cases where I have seen, they have not, some sort of haircut was accepted by the creditors. And though they don't get the entire immunity or insulation as seen in the CARP proceedings, but during the liquidation, it is possible. So as a consultant professional, what I see as is all of us have a huge opportunity there when it comes to a company which is undergoing liquidation, and in the initial 90 days, all of us can, I feel that there is a huge opportunity for us to see whether a plan can be brought in and structured in such a way that the liability, there is a scope for a mediation, there is scope for negotiation, and an informed decision, so that the liability can be reduced. And it doesn't end there. It will get the sanctity. It will be wholly incomplete without the sanction of NCLT. So all those things can be put up as a compromise agreement and taken before the Honorable NCLT and for approval, so that with all these benefits, they can take over the company. That is something which I have thought there's an opportunity for all of us, for people who have got good legal acumen to convince the court, and also persons who have got good creative financial to financial engineering, I would say, to bring up with a plan so that how to run this company going forward. And once the resolution, assuming doesn't happen there in 90 days, then in the liquidation regulation, they have mentioned about mode of sale, how can be sold, how it can be sold, assets can be sold. So here the liquidator will apply his mind. Again, he'll go for a sale notice, and he will have to maintain the minimum reserve price, which is the registered valuer's price. And what he will do is he will put for auction, and of course, the code says within 30 days, you are supposed to get the money. If it is not received within 30 days, up to 90 days, you can extend, provided the person, successful auction bidder, gives you with interest of 12%. And beyond 90 days, what will happen? You can forfeit, but then there is no amendments coming up. In couple of cases where I have seen, typical of Malayali, they will go and put up a writ petition before Honorable High Court and stay this thing. but be it as it may. So once the realization happens, the liquidator has to ensure that first he should take the first liquidation cost. There comes the play of Section 53. I again take you to the initial remarks by Philip Matthews, sir. They're talking about 53. Section 53 is a typical waterfall mechanism. So first realization ought to be used for meeting the liquidation cost and unpaid CARP cost in same proportion. And if at all there is any surplus, it has to go to the secured creditors and workmen of 24 months dues. Then assuming there is something left out, unsecured and employees 12 months. Assuming something is left out, goes to the government dues and other creditors, then to preference, then to equity. So once it is through, I have never seen a situation so far where a liquidation has had enough money, at least from IBC perspective, enough money to pay back to the promoters. I don't know, maybe there will be cases, but at least in the normal liquidation, it is Section 33 liquidation. Pathetically, most of the cases which we can see in India is not able to pay the full money. So there will be a list of creditors. The left out money will be paid to them based on the proportion which they have, and left out would be compliance report. A dissolution dissolution application has to be filed before the Honorable NCLT. There is a Form H again also. This is an affidavit by the liquidator saying that, look, this is something, saying that we have complied with all the rules and regulations. These people have been given this much money, and those people who cannot be tracked, who is no more, that money has been given to insolvency, bankruptcy boards, corporate liquidation account. So typical of, all those things are same as Companies Act. And once he files with liquidation for the dissolution, and the court is convinced, court will give a final order dissolving the company. Now, this is the process. Now, what are the challenges which can happen during the liquidation stage is very, very interesting. There will be assets. There will be some charges created. A typical company which is into liquidation will normally will have thousands of cases. All those people would have filed a money suit in civil courts, and that will have an encumbrance. And if you take the encumbrance certificate, there will be there. And most often we have seen that government regulators, they will never bother to lodge a claim, be it village or corporation or whoever. Minimum Wages Act, all those things those people will never lodge a claim and come up in the last moment for making their claims. I have come across a couple of cases like that. As a liquidator, I found it extremely difficult. The minimum wages, the Labor Department came up for a revenue recovery proceedings, then I had to go to Honorable High Court of Kerala for a stay. They gave, but then I'm saying, then another challenge which during the liquidation, what we've come across is, first charge of the asset has been given to X bank, then pari passu charge to another bank. So now I think that case is settled. In the code, when it comes to Section 53, nowhere talks about first charge, second charge, or something like that. Nowhere. So basically, code says it has to be secured creditors. So what practically happens is there have been instances where then stakeholders say that, look, we will not complain. Let them get the first charge. Let them pay. Anyway, we know that there are assets of the company, other assets of the company. We'll wait for that. I've seen a couple of cases in that way also. Whether it's a violation, I don't know. But then that is according to me, that is the beauty of liquidators, ability to convince, and the fact that the company had assets, multiple factors. So this is the position. So during the liquidation also, there will be a lot of cases, and Section 33(5) of the Companies, IBC says that there will not be any case lying against the company. And if at all somebody has got agreed, please lodge against, has got any claim, please lodge against with the claim liquidator. And if he's agreed, okay, section 42, he can go. But the beauty is, assuming the company wants to take an legal action, then prior sanction from NCLT is required. So that is also a very important thing. So because apart from the progress reports, apart from the periodic, preliminary report, asset report, and all those, there are a lot of reports to be filed by, liquidator in the case of IBC also. But here what happens is the tribunal has to be made aware as to code says lesser, time-bound program. 1 year, within 1 year, you have to finish the liquidation proceeding. So why do you want to go for a case? Ask them to lodge a claim here. So still, if it is in a solution, if it's in a situation that you need to approach, you need to take a legal action, then prior sanction is needed. That is the position. And when it comes to IBC liquidation also, there are a lot of forms in terms of, liquidation regulations, also a lot of forms there, typically Form H and all those things. The way when you want to send money to IBBA for the, the persons who have not, lodged claim or they've claimed, but then they count off, something like that. So full of forms, easy, ease of doing business could be, that is the reason, I don't know. I'm done, 5:46. Vijay, over to you.
Thank you very much. Now the floor is open for any questions. That, as we know that this topic is a little bit complex, covering all the areas of the Companies Act as well as the IBC. Shankar had presented it very well. And we have around 13 and 40 participants over here. I require that if there are any questions specifically, you may ask him the questions, and the floor is open for questions for 5 minutes.
And if I don't have an answer, you should answer, Vijay.
Any questions?
The luxuries we are having, luminaries in this, if you ask some questions to Philip, sir, he will talk about 1970 when he started practice.
Shankar,
Yes, sir. Sir,
good evening, Shivakumar here. Maybe I missed out 10-15 minutes. See, the one thing I could not understand was, what do you mean by this liquidation as a going concern?
Sir,
That's a new
something like, see, the company has got assets. See, what is the essence of IBC? IBC doesn't say that it is an insolvent company needn't be, and a defaulting company needn't be an insolvent company. Can you appreciate the difference? A defaulting company needn't be an insolvent company, meaning I made a default, but I've got assets. I've got plant and machinery. I've got inventory, but I don't have the, I've made default. For example, typical SR, Bhushan Steel, everyone which has gone into typical, insolvency proceedings, they were never an insolvent company. They made a default. They made default. So assuming the company CRP process could not find a logical solution of a resolution plan, companies still doing business. For example, in one case in Kerala, I'm not mentioning the name, it still continues. It's liquidation. It is generating income, pharmaceutical or some healthcare, Ayurveda. So what happens theoretically here is companies having plant and machinery, companies having cash not to pay the debts, but not able to pay the debts, but able to run the company. In such case, liquidator should have should think about selling the company or liquidating the assets of a company as a going concern. For example, he will say that this is for example, a sale notice can come in such a way that this is a running company into liquidation, having these resources. Anybody who is interested to take over these assets with a reserve price. So they are not dismantling the assets of the company and selling off. They are not dismantling. They are selling as a company as a whole. That is the essence. So in Kerala, couple of cases can come in another 2 months. Otherwise, as a going concern in the liquidation stage, I am yet to see in Kerala. But in I forgot the name of the company. It's not Spencer. Some company. Sterling Biopharma, something like that. That's a company which has gone into liquidation, and liquidation as a going concern was emerged out of it. So, sir, basically they are not selling off the company in piecemeal. They are cohesively selling the company whole assets so that, or a part, assuming the company has got two divisions. One division is doing well, another division is doing pathetically bad. So this company or division where this can be taken over by a group for running their business, that can be taken care of. That is running, as a liquidation as a going concern. അങ്ങനെ ചെയ്യാം അതാണ് അതിനകത്തൊരു നല്ല ഫൈനാൻഷ്യൽ എഞ്ചിനീയറിംഗ് ഒരു ഓപ്പർച്യൂണിറ്റി വരുന്നതാണ്. അങ്ങനെ കണ്ടിട്ടുണ്ട് വെളിയില് കൊച്ചി NCLT വന്നിട്ടില്ല.
പക്ഷെ അതില് കമ്പനി അങ്ങനെ തന്നെ നിൽക്കൂലോ അല്ലേ?
നിൽക്കും അതാണ് സാർ. സോ ഇറ്റ് ക്യാൻ ബി ലൈക്ക് can be
that is not possible in case of other kind of liquidations, and the voluntary liquidation or for the normal under this 271 liquidations you cannot operate as a going concern, right? Only for the CAR, because intent of the CARP is to revive the entities. So the NCLT is actually giving a last minute chance for the entities to get revived through this process, because they don't want the intent to be failed. That is what I think it is. Otherwise, liquidation is not possible when the company has to shut all its doors and stop its business. Otherwise,
but in the 271 liquidation also, a wording given that liquidator has to ensure that company can be operated for the beneficial liquidation of, beneficial way, so that liquidation as a going concern. Basically, it is, interpreting in such a way that don't kill a company. Possibly you run it as a skeleton or take over or something, for give some pittance and take over the assets. That could be the reason. Yes,
yes.
Gautam.
Yes. Hi, Mr. Panikkar. I've spoken to you over the phone, I think.
Yes, I remember.
Right. So I had a couple of questions. One was, do you think that there is any, so if I were a company that is potentially defaulting on debt and I'm anticipating that a creditor might initiate IBC proceedings against me,
Okay.
is there any potential benefit that I gain from preempting that by opting for a liquidation under the Companies Act? So passing the special resolution, jumping the gun, and opting for the Companies Act proceeding. That's one. And sort of follow up from that is, assuming that I do trigger, or there is a trigger of Companies Act liquidation, does that sort of preclude the possibility of a subsequent IBC proceeding starting? Because I understand that there is a moratorium, something like a moratorium under the Companies Act as well.
You're right. Actually, when it comes to special resolution and other things, it is a responsibility on the directors or the company's part that you are not going to, the intention is not to defraud. For example, you have a liability, you don't have that asset, and assuming the GST people are going to come very soon, so there is no point in continuing and paying off. Every time they will send you a notice, so that we can give all the documents. Let it be as transparent. Say the company is not possible to run like this. I want to liquidate the company, wind up the company. It is possible. It is definitely possible. Only thing is, let not any document be left alone. Be as transparent as possible. And in one case which I have seen, the moment the company Section 7 was on the verge of being admitted, suddenly the company says that no, we are withdrawing. Actually, I was happy that company may, instead of me going for Section 10, good that these guys came. But you know what happened? Section 14, they've taken the DRT route, and then we don't want CARP. It's a costly affair. Here we'll just take over this company and sell it off, and we are not here to resolve we are not having that large part. So answer to your specific question, Gautam, is very simple. Possible, but be very careful, because documentation has to be so perfect that assuming somebody, because I'll tell you, when it comes to winding up committee, when it comes to a possibility of advisory committee, winding up committee, official liquidator is a bureaucrat. He will not, his first this thing is, let not anybody come in my way of getting regular pensions. I have had enough. This example, that example, he will have tons of experience. So he will ensure that, for example, in one case where I have handled, I have for a academic purpose, I've shown. He said, no, how can it be possible? Not in Kerala. Okay, how can it be possible? Why you have shown this liability to the sales tax people? There is a case pending that the tribunal and auditor's report says that this particular loan, claim is there that has not been settled. All those things, liability has been disclosed in the balance sheet. Therefore, winding up committee, when it comes to official liquidator, he's a government man. He's a pakka bureaucrat. He will ask you goods. He will ask you questions. You need to have clear question as to how is that the reason for coming up with this. So that is a possible. But I appreciate your thought process. No legal bar in doing that.
Thank you.
Any other questions?
Bijoy, it's not actually necessary that you should prompt people to ask questions. And it's very, it is.
So as we have no other questions, with the permission of the chair, shall I deliver the vote of thanks? So, good evening, everyone. On behalf of NCLT Kochi Bar Association, I am honored to deliver the vote of thanks for today's event. Firstly, I would like to thank Mr. Sankar Panikkar and extend our heartfelt gratitude to our esteemed guest, Mr. Sankar Panikkar, for delivering such an engaging and insightful talk for all the members who are attending this meeting. Shankar, your expertise and perspectives have actually truly enriched all the audiences who have attended this meeting on the specific topic of liquidation under the Companies Act as well as the IBC, and you have taken really good effort to enrich us with this knowledge. And thank you, and your efforts are really commendable from that account. And a special thank for the audience who have attended throughout the meeting. We have a very good attendance throughout the meeting from the beginning till now. And I'm thanking each and everyone for the wholehearted participation and support. And I would like to thank all the members of the management committee of our executive committee of NCLT Kochi Bar Association for taking the lead in organizing such a wonderful event. And we look forward to conduct this kind of programs in a regular and a fortnightly manner. And thank you very much for the participation once again. Have a good evening, wonderful evening. Thank you.
We will have, Vijay, I'll take 30 seconds. We'll have joint session with KIPF also. You're also part of it. We'll conduct a lot of.
We will arrange. And that off late, we will be planning a session on the criminal, IPC and other laws, which is actually now notified. And immediately we'll have another session on that topic also.
And another law has been passed by Kerala state stopping the, cohesive action against the lenders. We will have a joint session there.
Okay, sure, we'll do that. So thank you, everyone, and with your permission, and we are binding up the session.
Thank you to Philip, sir. It should be 8:30 there. Have a nice dinner there.
Thank you very much.
Thank you.